All right, I think we're getting set up. Welcome everyone to the Ray Law International channel. My name is Anthony Ray. I am your host for today. And today we're going to talk about the e-visa categories. This is a category that's dear and near to my heart. I really love working with our clients, our corporate clients, and individuals with the e-visas. It's just the U.S. consulates are easier to work with. They're straightforward. They follow the rules. For the most part, there's a lot less subjectivity that we experience. But albeit we're going to be talking about e-visas today. However, before we get started, let me tell you a little bit about Ray Law International. We're a business employment-based immigration law firm. We have offices in Michigan and Chicago where we represent clients nationally and internationally. We're really looking to help corporate clients streamline their process. Additionally, if you already have an immigration law firm, we're very open to working and handling a lot of the overflow. We know that there's a lot of immigration work that needs to be done, a lot of deadlines, and sometimes your current law firm just is, stretched a little bit with the resources they have. So please, our number will be shown throughout today. So you can always reach out to us. I'd be more than happy to sit down with you, tell you a little bit more in detail of what we do and how we're different and why our clients really love working with us. And then also kind of guide you and share how we can make your lives a lot easier. All right, but before we get started, as everyone knows, the October, or you should know, not everyone knows, but you should know that the visa bulletin is for October is out. We're going to take a quick look at that. Let me get this up on the screen here. Just a moment. Let me see where we can add this in. Just a moment. All right, guys. So as you can see on the screen, this is the October 2024 Visa Bulletin issued by the Department of State. And let's see. We're getting the full screen on here. Let's just one moment. I want to make sure you guys can see the whole visa, the bulletin. I think what's showing on the screen is a little bit different. All right, so what I'm going to do, I don't know, some technical challenges. Let's remove that and add it back in. So the good news is there's many categories. We're coming into a new fiscal year. So in this case, we're going to get new visa numbers from October 1st and November. So we should see a lot more detail. Here we go. This is what we want. We want to share the whole screen, not just the document. And we'll get this added in for everybody. There we go. All right. So October 2024 Visa Bulletin, family-based cases. You can see the numbers here. This is the final action date. This is when you actually can get the green card. I usually don't go into too much detail because it's really case specific depending on which category you are in. For those under the employment, the one thing I did want to note, we had some people call this past week who are lawful permanent residents, green card holders, and they want to get married. So in many of those cases, if you look at when the green card, the I-485 can be filed, it's actually just a couple months out. Here it's July 2024. We're here in September 18th. That's not far out. So what that really means is you can file the I-130 anytime, but you then have August, September, just a 2-month wait before you can go ahead and file the 485 for our LPR. So keep that in mind. There's a lot of strategic things that you can do. October is the month to file if you are green card holders marrying another non-citizen. So take advantage of that. don't worry, you don't have now. Let's go back up. Now they still have to wait because there's no green card available for a good 3 years. However, you can still at least file for adjustment of status and be together while you wait out the 3 years for our government to go through the process and actually get you the green card, or in other words, when a green card will be available. So that's one great thing about the family-based categories. Check these out. October is out on the State Department. Let's take a look at the employment-based categories, which unfortunately, we talked about employment-based, I think, last month. We'll continue to talk about this in the future, but this just is numbers for when you can actually get the green card. Notice here that for the EB1s, it's current for all countries except for China and India, Mexico, Philippines. If you're under EB1, A, B, or C, you want to file, take advantage of that in October because your green card's available. For all others, here is when you can actually file the green card application or start your immigrant visa process abroad. These numbers are pretty good, actually. I mean, India, yeah, there's a few that are backed up to 2013, but there's just a lot more people coming from those countries. China is not very bad, and all other countries are really reasonable. Okay? So October 2024, Visa Bulletin is out. Make sure you check that out. If you don't know what's going on or don't understand how this applies to your case, call the number, set an appointment. And if you have a new case that you want to file, we'll be more than happy to do that. Otherwise, if you already have an attorney, ask them, what the new Visa Bulletin, how that impacts your case. All right. So we're going to get right into it. We have a lot to cover today. So in today's immigration meeting today, what we're going to do is we're going to cover the E1, the E2, and the E3. Okay, E1, E2, E3. A quick overview. We're going to go over the requirements. We're going to go over a few questions for each of the three, and then we're going to do a case study to kind of give you an example of how these things are applied. Okay, I hope you like this. As you have questions, feel free to put those in the chat. We're here, we're here to educate you, give you information, but you may have questions outside of the E1, E2, or E3. Feel free to put those in the chat. We'll try to get to those today. Those are going to be our priorities. And if we don't get to everything today, that's all right. We can always follow up or present it a little bit later. Okay? So as we get started, and today I have a couple people helping me, so if I miss something, they're going to let me know that there's questions in the chat. So want to thank everyone for joining us today. I know everyone has a busy schedule. We really do appreciate your time, your interest in our firm, in the topic of immigration. And, just one thing before we get started. I remember this past weekend, I was visiting an apple orchard, very popular here in our state, the state of Michigan, and was wearing our law firm logo with immigration. So it always sparks a lot of great questions. And the comment I got from a lady was basically, oh, immigration, that's a tricky subject or a tricky topic. And I think all too often, many Americans have this illusion that immigration is bad, okay? It is not. That is just one aspect that we all see or the media just chooses to put out there. There are so many positives. And even though I didn't have the opportunity to share with her, immigration impacts every area of your life. Doesn't matter who you are in the US, doesn't matter where you're at. Immigration impacts it, whether they're, growing your products, harvesting your food, manufacturing the equipment or whatever, whether they're a doctor or a nurse, or even your politician, okay? Immigration is in every aspect of your lives, and it's a very positive. I think if people really understood immigration better, they would see that, yeah, we have our challenges as a nation with illegal immigration. and our politicians have to figure that out. However, we greatly benefit in so many ways from immigrants that come to the US, whether that's starting businesses, supporting businesses, you know, being leaders in our countries, or you know what, even saving our lives. You look at the doctors who are from abroad, they are saving your lives and taking care of your health. Okay, so we are always advocating a very positive view on immigration, not just what the media decides to share with us. All right, guys. All right, that's a little experience that I had. We are now going to shift over to the E1. Okay, now the E1 is the Treaty Trader Visa. Okay, and we're going to go over some of the requirements. Okay, first of all, the treaty must exist between the United States and the foreign country. Okay, now there's a list that shows which countries has a treaty and which one it actually authorizes in E1, E2, or in E3. And as long as we have a treaty in place, that's great. Now, what happens if the treaty goes away or the treaty is canceled? Which has not happened very recently, but let's say it does. Then the E category goes away for that, for those nationals in, excuse me, for those nationals in that category. Now, I have not experienced this in my lifetime in the past 25 plus years. However, theoretically, us attorneys love a lot of theory. Theoretically, that could happen. But realistically, it's unlikely. Um, Maybe if there's some kind of war that, comes up or something very bad, but everyone is in well, let's say most countries and most businesses are in the business of surviving, growing, making money, and continuing to do that. Okay. Most people don't want to throw that out the door, get paid nothing, and have their economies sink. Okay. So, treaty is required. The next requirement we're going to go over is the majority ownership must be held by the nationals um, of the trading company. Okay, so we'll look at that today. The ownerships. Next, the foreign country citizenship must be held by the employee as well. So if we have a French company that's majority owned by French nationals or French citizens in this case, then we're going to make sure that the employees are all going to be French citizens. They don't have to be born in France, but they have to be citizens. Okay, we'll take a look at that in our case study. In this case, E1, we're talking about trade. Okay, so the company must be engaged in trade. Okay, it must be continuous. It can't just be one time and done. It must be continuous. The trade must be substantial. Okay, it can't be 5% or 1%. Additionally, this is very key under the E1, and oftentimes we kind of encourage companies to do the E2, but the E1, the majority of the trade must be with the US. Okay, now the US right now is doing very great, and we're probably one of the major trading partners for most countries, but we're not the only one, and things do change and evolve over time. So should something change, let's say your major trading partner becomes the EU or China or some other entity or some other country, excuse me, then you would not qualify under this category. That's why we kind of fancy the E2 a little bit more than the E1. However, some people still like to stick with the E1. Now, um, in addition to having the principal trade be between the U.S. and the treaty country, the last point here is the employee or principal must serve the company in a specified capacity that's managerial or essential skills. Okay, we're not going to get into the details today of what essential skills and managerial and executive are. That's a whole nother half hour, but feel free to reach out to us and we'd be happy to talk to you about that. So some of the questions, we're going to go over 3 quick questions under E1. What is substantial trade? Okay, substantial trade really means, in this case, it has to be probably more than 51% of the trade that you do. So if a company, you know, trades 100 million a year, then we're looking at make sure that it's substantial, that I would use the threshold of 51, maybe 60% of the trade should be with the US in that capacity to meet that. Uh, Typically, it's not a problem like right now because the US is a major trading partner with many countries and companies. So right now, not a major thing. However, again, economies change and things could change in the future, which would impact the E1. Next question: how long may the treaty trader or investor stay in the U.S.? Now, in most cases, the treaty trader is going to be granted um, the E status for 2 years in the US, and they're going to be able to renew that indefinitely. Now, the visa stamp that you get at the US Embassy abroad will vary. Most countries will issue it for a 5-year period. However, there are countries where the US Embassy decides to limit the number of years the E visa is granted for. So just be mindful. Always check your documents. Always know where you're filing. But either way, you're able to stay in E1 status forever if you so choose, theoretically. Now, there may be other issues that arise, you know, but we won't get into those right now because there's so much to that. So if you have a specific issue or question, feel free to, you know, about the E1, put that in the comments. The third question, this one is a little bit more detailed and interesting. We often have this from time to time. So the next question is, I've previously been found ineligible for a U.S. visa. Can I still qualify for the E visa? For many reasons, which we'll talk about in a minute, some people just don't qualify. So in this case, those applicants who are ineligible for a U.S. visa due to criminal convictions, immigration violations, drug charges, or other similar reasons must appear in person to determine their ineligibility and likelihood of a waiver. For such ineligibility, applicants requiring a waiver face a likely wait of several months for a waiver to be processed by the U.S. Department of Homeland Security. Even if the applicant satisfies the requirements for the E1, there is no guarantee that the waiver will be approved. So if you have some immigration violation, be warned. A very common one, but it's not really a violation. Oftentimes we see individuals with DUIs or driving while under the influence or drinking and driving or OWI, depending on the state that you're in. In those scenarios, those circumstances do not require you to get a waiver. However, most U.S. embassies will test to see if you are still addicted to alcohol. So if you have a DUI and you're required to go give a blood test, don't drink or go out drinking beforehand, or worse yet, participate in any drugs. So even if it's medical marijuana, you don't want the State Department to deny your visa because you didn't meet those requirements. All right, so let's jump into our E1 case study. All right, so a little background here. We have, and all this is fictional. This is not one of our clients. However, we have Hiroshi Yamamoto, who's a Japanese national. He is an international trade specialist. He works for a Nippon Trading Company in Tokyo, specializing in importing American-made electronics from Japan. Nippon Trading engages in substantial trade with the U.S. firms, importing about $20 million worth of electronics annually with the U.S. Remember, we're dealing with E1, so we're really looking at trade. Hiroshi Yamamoto is a senior executive at Nippon Trading, responsible for overseeing firms' business dealings with American suppliers. Due to an increase in demand for U.S. electronics, Hiroshi's company is expanding its trade volume and requires him to be stationed in the U.S. for a period of time to establish new partnerships, manage logistics, and negotiate pricing with suppliers. All right, so that's our backdrop. Let's jump into what are the requirements. Nippon Trading is owned by Japanese nationals and Hiroshi is a Japanese citizen. We need substantial trade, right? So Nippon Trading conducts substantial trade with the U.S. by importing more than 20 million worth of goods annually. The trade is frequently consisting of multiple transactions over the year. More than 60% of Nippon Trading exports or imports are from the U.S., which satisfies the requirements that the majority of the trade is between the U.S. and Japan. Hiroshi is a senior executive with over 15 years of experience of international trade, and his role is crucial to establishing and managing business relationships. Those are key words. It's crucial, vital, essential. We're looking at essential worker. He is the primary point of contact with American suppliers and has negotiated key contracts in the past. All right. So, in this scenario, U.S. consulate in Japan approves Hiroshi's E-1 visa, granting him the ability to reside in the U.S. to manage the growing trade relationship between Nippon Trading and U.S. suppliers. This visa allows him to stay for 2 years with the possibility of renewals as long as he continues to oversee the company's substantial trade with the U.S. So this is a great example of how the E1 works. As mentioned before we move on to the E2, make sure that trade stays where it's at. We tend not to focus on trade because trade ebbs and flows depending on the products and services and the competition throughout the world. So you want to be mindful of when you're dealing with the E1 to make sure your trade remains that very high and substantial. All right, let's move on to E2. Everyone ready? Remember, if there's questions that you have, thank you guys for joining. People who have jumped in, thank you for joining. If you have any immigration question, whether it's regarding the immigration topic today, or anything else, write it in the chat. Let us know what's on your mind. Maybe you have some questions about how immigration will be impacted by the upcoming presidential election. We'll try to touch base on that in October as we get closer. We're less than 50 days out for the U.S. Elections. But if you have questions, go ahead and put it in the chat. All right, let's hop on over to the E2. All right, under the E2, let's look at some of the requirements for the E2. Just one moment, let me get my notes organized. Great. So under the E2, remember this is treaty investor. We tend to like the treaty investor because you just make the one-time investment and you're pretty much good to go for the rest of the existence of the E visa holder, E company registration. Now, first, like the E1, you have to have a treaty. A treaty must exist authorizing the issuance of the E2 visa. Now, there are actually treaties out there. No one ever pulls them or attaches them to the application themselves, but they are out there, and there is language in there authorizing E2. Next, the majority ownership or control of the investing must be held by the nationals of the foreign country. Citizenship in the treaty country by the principal investor or the enterprise seeking admission must be present. Okay. Again, just like the E1, if we have a French company, employees must be French citizens. Now, if you naturalize and become a French citizen, you qualify for E. We have many of those cases, especially closer to home in Canada and in Mexico. Next, the employee or principal must serve the company in a specified capacity, managerial or essential skills. And next, the investment must be active. You can't just take $1 million, put it in the bank, and then ask for the visa and do nothing more. The funds must be actively invested and must be at risk. Okay. Now, we normally don't have this issue, except for those people that say, hey, I don't want to use any of my money, and can I still get the visa? Typically, we guide them properly so that it's not an issue. All right, let's look at a few questions. What is a substantial amount of capital investment? Well, that's going to depend on the size company or what you actually put. So in this case, if you're dealing with $1 million company, or you're going to have sales of $1 million company, then what is substantial? It may be 200, 300,000, 500,000. If it's a manufacturing plant that's going to be doing 50 million a year, well, 5, 10, 20 millions in equipment and buildings and all of that, that is going to be substantial. So it's going to depend on what you're setting up. Is it a small restaurant down in Chicago, or is it a huge, large manufacturing plant in Colorado, creating manufacturing parts and supplies for satellites? Whatever it may be, you want to make sure that it's substantial. The attorney can help with that. And we do that all the time. Next question. Are joint ventures permitted? Absolutely. Now, the key with joint ventures, let's say we have a French company and a German company, okay? The one that has control is the one that is in position for doing the treaty. Now, it's not always clear. It's not always strictly enforced. So, you may have a couple Germans that may still qualify under the E. It may depend on the position the person is holding. So there's many other factors that may come into play, but most, we do joint ventures all the time. They're very common and people have no problem. Now, what does impact that are the company reorganizations and restructuring. When that joint venture ends, what happens to the employees? Unfortunately, it appears that a lot of the business people, decision makers at top, tend to forget about those employees. Immigration tends to be an afterthought. And often us immigration attorneys are scrambling, trying to fix the immigration statuses of individuals to make sure that they can continue to work and reside lawfully here in the U.S. So my encouragement, if there is restructuring or a potential for a buyout or a takeover of a company, get the immigration attorney involved, get us involved early on in the process so that we can make sure that not only the visa holders are taken care of, which we're talking about today, but also those who have green card cases pending, which is going to be impacted by a major company restructuring or change. All right. How are we doing? Any questions out there? Feel free to ask questions, put them in the chat. Any immigration questions? We want to hear from you guys. Thank you for joining us. Let's go to our next question before we head to our example. Now, what is e-visa company registration? A lot of people are familiar with the e-visa, but they really are not really familiar with the company registration. Most, if not all, embassies require that the company be registered. So what is required? In this case, for example, the e-company registration indicates that the U.S. officer has determined that the company has already met all the standards. This is great. It's kind of like the blanket L. It's like, hey, we've already pre-approved the company because you've met all of the investment or the E1 treaty trader requirements, and you don't have to prove that each time, okay? And during the registration period, if the treaty enterprise seeks to send additional employees to the U.S. on an e-visa, those employees may apply under the procedures outlined by the employees of registered companies. Unless there has been substantial changes to the enterprise that would jeopardize its e-visa status subsequent to applications, can focus on changes to the enterprise. In this case, if there's major changes, you're going to have to update the U.S. Embassy, provide them updates. And we want to make sure that, it doesn't impact the employees. So we had this recently with one of our companies here where there's a major company change, and they reached out to us to kind of find out what's going to happen to our e-visas. Well, a lot of information, as we talked about, what's the structural change? What is it going to look like? Who's going to be the owner? What's the ownership of the new parent company? All of these things must be analyzed to make sure that the e-company registration and the employees are protected. All right, let's take a look at our E2 case study. This one's pretty good. We're going to move to Italy. Just one moment. Let me pull it up. And we have our candidate here for our E2 example, case study is going to be Maria Rossi. All right. And I do not speak Italian, I speak Japanese, so apologize if I mispronounce the name. But here, Maria Rossi, this is a really good one. Italian, of course. She's going to open up an Italian restaurant in Miami, Florida. She's going to invest $250,000, and she plans on having 7 full-time U.S. workers. Maria is an experienced restaurateur from Italy. After years of success, her native country, she identified a business opportunity in Miami, a city known for its diverse and growing culinary scene. Maria decided to open a high-end Italian restaurant in a trendy Miami neighborhood, focusing on traditional Italian cuisine with fresh ingredients imported from Italy. The restaurant aims to attract food enthusiasts and provide a genuine Italian dining experience. Now, we're dealing with E2, so what's important? Our investment. Okay, for her, 250,000 for a restaurant is substantial. Okay, that's going to include her leasing, renovating the space, purchasing commercial kitchen equipment, importing Italian furnishing, decor, and hiring U.S. workers, and of course, marketing and promotion of her restaurant. Now, what's sort of the process that Maria's going to need to go through? First, she's going to need a detailed business plan. We recommend a 5-year business plan that kind of outlines the 1, 3, and 5-year goals for it, for the business. The business plan will demonstrate her restaurant will contribute to the U.S. economy and employ U.S. workers. Now, we have to make sure that the funds that Maria uses are legal. So Maria needs to provide evidence of her investment, including bank statements, lease agreements, equipment purchase receipts, invoices from contractors who completed renovations. She also showed that the funds were irrevocably committed to the business. This is where we are, putting our money at risk, okay? We can't just put it in a trust account or leave it with someone and, not bother with it, a trustee. It's got to be at risk. Also, the government wants to make sure that these are legal funds. Okay, therefore, we want to see how she generated the $250,000. Oftentimes, we'll use tax returns. Usually, if it's coming from a bank, it's legitimate because the bank would not be holding illegal or criminal funds that are related to criminal actions. Now, this is a very unique aspect after we've shown substantiality of the investment is the intent to depart. You're going to say, Mr. Ray, why do I need to show my intent to depart? I want to sit here, grow my restaurant, and stay here. However, the e-visa categories are not dual intent. Therefore, the E2 visa holder has to show that they have intent to return. Maria must sign an affidavit stating her intention to depart the U.S. once her E2 visa expires, unless it is renewed or changed. It's a little counterintuitive, but it's more procedurally rather than other visa categories. So, for example, if you're applying for a B1, B2, this intent to return is going to be a very high standard to overcome. Here at the E2, E1, and E3 standard, the bar is really low, meaning they really don't even care. But it is an aspect or a characteristic of this visa category. And then finally, the restaurant was expected to generate sufficient revenue to support more than just Maria and her family. The business plan projected the creation of 7 full-time jobs for U.S. workers within the first year of operation, meeting the non-marginality requirement. Now, Maria, and let's find out what happened with Maria. Maria's E2 visa was approved with the initial 2-year period. She successfully opened her restaurant, which gained popularity due to its authentic menu and atmosphere. Over the first year, the restaurant exceeded its financial projections, and Maria applied for an extension for her E2 visa, presenting updated financial reports, employment data, and to demonstrate the continued economic contribution. Now, one of the great things is what we can always talk about later is Maria can also apply for other visa categories or apply for a green card. Okay, so that is E2. If you guys have questions about the E1, E2, write them in the chat. Drop a question or two there. Let us know. Or even if you don't have a question, let us know where you're from, maybe what you want to hear in one of our future videos or live streams. So please, let us know what you think. Let us know what you're interested in, and let us know, what you think would or what issues you think should be addressed in U.S. immigration. All right, now let's move to our third and final one. As we move along, E3 visas. The E3 visa is for Australian citizens, and we're going to go over some of the requirements. There's quite a few, but not too many that we can't handle in a short period of time. All right, the first requirement for the E3 is to qualify for the E3, the applicant must demonstrate that he or she has a legitimate offer of employment, has to be sponsored by a U.S. employer. Usually an offer letter is sufficient for that. The position that he or she is filling qualifies as a specialty occupation. Okay, specialty occupation is a term of art used in immigration. Generally speaking, it's a position that requires a 4-year degree. It's determined by the USCIS and Department of State and the Department of Labor as well. We have to show that that the applicant is a Australian citizen, okay, not national. Doesn't mean they don't have to have shown that they were born in Australia. They have to show that they are a citizen of Australia. Also, we have to show that they have the academic and or experience qualifications for the job being offered. Next, we have to demonstrate, like that affidavit we just mentioned, that they're going to be here temporarily. Seems a little counterintuitive, but that's what we are faced with the E-visa categories. They are not dual intent, meaning you have to show that you're going to go back. Typically, again, we do an affidavit that once their E3 is done, they're going to return back to their home country and, or leave the U.S. We also, for positions that require a license or certain special permissions, we have to demonstrate that they have that. A very common one is a civil engineer. In many states, a civil engineers require a certain license or certification. That certification would need to be presented in order to get the E3 approved. Another unique aspect, which is different from the E1 and E2, we have what we call the Labor Condition Application, or LCA. This is where we get a certification by the Department of Labor what the prevailing wage is going to be for the position offered and the location. So if you don't know what an LCA is or Labor Condition Application, let us know. Most companies or HR or immigration specialists do reach out to us. We'd be more than happy to give you more information, but that's one of the requirements for the E3. And finally, for the E3, there is a quota of 10,500 given each year. I've never received any notification that that cap has ever been reached. Life is great in Australia, or perhaps there's just not enough people that meet the professional category that want to be in the U.S. Applying for these visas. But if you do have someone from Australia or know someone, this is an excellent vehicle for them to come to the U.S. and work for the work in the U.S. Now, another really great thing about this is, like the E1, E2, there's no term limits. Now, they're still going to get it for 2 years, but they can renew that indefinitely. Okay, so this is great for employers, great for Australian citizens who are professionals to come over here and work. Now, let's move to our questions. We have 3 quick questions, and then we have a case study for our E3, and then we're going to wrap it up. So the first question is, why are only Australians eligible for this visa? A very good question, and it all has to deal with that's what legislation states. Why? I didn't go into the history of this. It may be interesting. It may not, but basically a politician, everyone agreed that this special category should be carved out for our Australian friends, and it is now sort of ingrained in our Immigration and Nationality Act, the INA, and the regulations. So um, I think you just need to lobby a lot harder if you want one for your own country. So don't give up. Hopefully, the State Department and others can kind of lobby back and forth to get a special one for your country. That would be great. What is a specialty occupation? We just talked about this a little bit, but it's typically a position that requires a four-year degree. Think of engineers, software engineers, computer science, psychologists, doctors, um, professors at universities, and many, many, many other professional occupations. But simply, the minimum requirement would be a four-year degree. Now, the next one is also very keen for everyone in the E category is, may spouses work? Can my spouse make some money while they're here in the United States with me? And the answer is yes. The great thing about this is in recent years, they've made it even simpler. Previously, spouses needed to apply for a work authorization document, EAD card. However, that is no longer the case. When they enter the United States with their check your designation. It should say your category with an S at the end, with spouse. That means that they have the spouse properly categorized and that they're automatically going to be authorized to work, which means they'll be able to go to the SSA, Social Security Administration, get their Social Security number, get their driver's license, and work in the U.S. workforce. Okay, so if there's oftentimes there's mistakes, so always check your I-94 online. We just had a recent error by CBP of spouse that came in and didn't have the right designation. There is a process to get that corrected. Okay. Let's see. Any questions? Okay. Again, if you have any questions, just let me know. We're going to jump into our case study and then we're going to wrap it up for today's live stream. Again, as you have questions, let us know. If you're watching this after our live stream, you can still post questions, especially on LinkedIn and YouTube, and we'll respond. You can always give us a call at our office at 888-401-1016. Again, that's 888-401-1016. All right, so our Australian individual, we got a little background for him. His name is John. John is a software engineer and an AI specialist. He's going to be working for ABC Tech Solutions in San Francisco. He's going to be making $135,000, which is above the prevailing wage in our scenario. And the employment is going to be full-time or indefinite. They want to keep him for a long time. John holds a bachelor's degree in computer science and has 8 years of experience in the software engineering field. What are the requirements? Main requirement is John has to be an Australian citizen. Okay, he proves that. Next, the occupation must be a specialty occupation. The job offered to John clearly qualifies as a specialty occupation since it requires specialized knowledge in software engineering and AI, which is in line with the E3 visa criteria. Next, does John meet the educational requirements? John's bachelor's degree in computer science from the University of Sydney meets the requirements for specialized occupation. A little note here, when we're dealing with foreign degrees, we often have to get what's called an education evaluation to make sure that John's foreign degree in education is equivalent to a U.S. degree in education. So we always, in almost all cases with foreign degrees, we secure an education evaluation. Prevailing wage. This is unique, which is different from the E1 and E2. The E3 does require a prevailing wage. ABC Tech Solution offered a salary that exceeds the prevailing wage for a senior software engineer in San Francisco, satisfying their wage requirement. This process, we're not going to go into too much detail, but basically we take in information, we submit that to the Department of Labor and get it certified, and then we submit that with the actual visa application if they're applying abroad or if they're changing their status in the U.S. with the USCIS. Again, temporary nature of stay. We have to do that affidavit. We have to show that the job, while the job is indefinite, meaning we want to hold it for a long time, John um, is entering the United States on a temporary basis. Okay, we have to show a temporary intent. Okay, and even though he can renew it each year or even apply for a green card later on, we'll talk about applying for a green card in these visa categories at another time. There are some limitations and things we have to address. Okay, all right, so. Um, in this scenario, John's going to be in Australia. He's going to attend a visa interview at the U.S. Embassy in Sydney and obtain the visa stamp. Once he gets that visa stamp, he's going to enter the United States. He's going to be granted E3 status for 2 years. Okay. And he's going to be able to renew that E3, sorry if I misspoke. E3 is what I wanted to mention. He's going to renew that E3 visa status every 2 years. He's going to need a new LCA, but he's going to renew that each and every year. So he can do that forever. Obviously, one of the challenges off of a salary of $135,000, while it's more than enough in many areas of the country, in the Bay Area, probably going to be hard to find housing. However, if you need help, we know a lot of people in the Bay Area that can help with housing in order to meet those requirements. So, guys, that's the outcome of the E3 for John. These are just great examples of how the E1, the E2, and the E3 work. All right, guys, if there are no questions, I'm going to thank you again for joining us today. Feel free, if you have any questions about the e-visa or any immigration, call us, get some clear direction, trusted advice on immigration matters, and we look forward to next month when we discuss another topic with you. In the meantime, you guys have a great week. Thank you very much, and that is all for today. Until next time, stay informed, stay educated, and stay on the right immigration path. Thank you.